turn around here. We're going to start off with some bill introductions. Representative Hoy.
Thank you, Mr. Chair. I have 25 RS 0481, prohibiting the carrying of concealed handguns in the state capitol and providing exemptions.
Committee, any questions? Seeing none, thank you. Bill accepted.
Thank you, Mr. Chair.
Representative Essex.
It was not. My apologies. I will do it again. RS 1604, requested by Representative Laura Williams, requiring previous convictions to be considered in determining bond when a person is arrested for certain sex offenses.
Representative, the unfortunate side of that is kind of outside of our scope of this committee, and I'm not sure, I'm a little unsure about that. We may have to reintroduce that bill tomorrow. Let me check on that for a minute. But right now, we're not going to accept the bill. But thank you. Are there any other bill introductions? If you do have a bill introduction, please come talk to me first. Seeing none, we'll move on. We're going to start right on in with opening up a hearing on Senate Bill 9, and Kyle will give us the introduction on that.
Thank you, Mr. Chairman, members of the committee. Under current law, land surveyors are required to file a reference report for each United States public land survey corner or related accessories with the Secretary of the State Historical Society and the applicable county surveyor, or in the case that there isn't a county surveyor, the county engineer. The report can be filed under current law and retrieved using electronic technologies if authorized by the Secretary, but it must be filed within 30 days after the reference has been made. And also currently a filing fee determined by the Secretary of the Historical Society has to be paid at the time of filing the report. I have that down as being $4 for each corner to which a reference is made. Similarly, if a survey corner or accessory is likely to be altered, removed, damaged, or destroyed, the surveyor must establish reference points for the restoration, reestablishment, or replacement, and then file a report again within 30 days. Failure to comply with these requirements can result in the suspension or revocation of a land surveyor's license. So under this bill, Senate Bill 9, it would extend the amount of time to file the required reports from within 30 days to within 90 days of the date the references are made. Additionally, when there is no county surveyor or county engineer to receive a filed report, the bill would allow the reports to be filed in any county office designated by the county commission. Senate Bill 9 would become effective upon publication in the statute book, and I believe this bill passed on consent calendar in the Senate. With that, I'd be happy to take any preliminary questions.
Committee, any questions for Kyle? Representative Osmond.
Thank you, Mr. Chair. I just have a quick, I don't know if you call it housekeeping, but it was introduced by Senator Bowers, but that's not listed on the bill itself. Is there a reason for that?
From what I recall, the requested by information rules are a little different in the House and the Senate. So for Senate bills, that information can be found on the bill's page on the legislature's website. If this bill had been requested in the House, it would actually appear on the bill itself.
Committee, any other questions? Not seeing anything. Thank you, Kyle. And first up on the proponent side, we're going to welcome William Haverkamp. William, welcome to committee.
Good morning. Thank you for the opportunity to share some information about this bill. I am Bill Haverkamp. I'm a land surveyor here in Topeka, and I'm representing the Kansas Society of Land Surveyors. I serve on the board of directors. This bill does make two subtle changes. It allows a county to designate an alternative office for the recording of or filing of these documents. I brought a copy of a reference report if anyone would want to see one. It's very brief. It basically shares what type of monument was either found or set by a land surveyor, some reference ties so someone else could find that monument at a later date, and then a little outline on, the recovery of establishment or how they recovered the monument, just a little detail for the next surveyor to move forward on. The other one extends the submission time frame. Originally it was 30 days. Our projects are so large anymore that we can't start them and finish them in a 30-day window, so we either have to submit intermittent reports to the Historical Society in the county, or we have to alter our workflow to where we do one part of the work, come back and do the reference ties at a later date. Time is money for everyone, so this just gives us a little bit more time to complete our work and do it in an efficient manner, and saves everybody a little bit of effort. So with that, I ask your support of this bill and would answer any questions if there would be any.
Committee, any questions? Not seeing any. I appreciate it. It must have been a great explanation.
We thank you.
Committee, I'd like to point out we do have a couple of written proponents as well. Seeing no neutrals, or we have, let me go back here. Seeing no neutrals or opponents to this, we will move on and close this hearing. Next up, we're going to bring up HB 2376, and Kyle, will you bring us up to speed on that?
Thank you, Mr. Chairman, members of the committee. A little quick background. So currently, CMB, for those who don't know, stands for cereal malt beverage, which is a beverage up to 3.2 alcohol by volume. CMB license currently allows a person to sell CMB and also beer that's up to 6% ABV. Cereal malt beverage license applications are prepared by the AG's office, and then they must be submitted to the city or the county where the business is located. The city or county clerk is the entity that issues the CMB license. And so House Bill 2376 would transfer the licensure of these cereal malt beverage retailers from the cities and counties to ABC within the Department of Revenue. It would also allow local licensure by cities and counties if they wish. I prepared a bill brief that has a comparison grid between current law and then the changes made in the House bill. I'm not going to go through it line by line, but I'm going to try and cover some of the highlights. You'll see throughout the bill there are different definition sections, starting with definitions in the Kansas Liquor Control Act, and then jumping down to Section 4, a definition section of the Club and Drinking Establishment Act. You'll see a lot of crossed out definitions and then inserted definitions, and those cross-outs and inserts are a mixture of, I think, just some technical re-alphabetizing the lists, but then there are also some new definitions added concerning the on-premise cereal malt beverage retailer's license and off-premise cereal malt beverage retailer's license, because under current law, the CMB license just refers to licenses. It doesn't split it off like that. So sections 1, 2, 3, and 4 are just making those conforming changes in definition sections. But when you go to page 9 of the bill, that's when we're finally in the Kansas Cereal Malt Beverage Act. That's on page 9. And again, it's making some changes to definitions. It removes the current definition of retailer. It replaces it with those separate definitions of off-premise, on-premise retailers. Additionally, in section 5, it adds a new definition of licensee. And then I'm going to jump actually to page 11 of the bill in section 6, where we start getting to more substantive changes. Under current law, it requires retailer license applications to be verified on a form prepared by the Attorney General and contain specific information. So in this section, it would require applications to be on a form prepared by the director of ABC instead of the AG's office. It would also remove the requirement for the applicant to state the length of time that they've resided in Kansas, which is in current law. Also on page 11, in current law, it requires a license renewal application to include a $25 fee that goes to the director, and the bill would increase that fee that goes to the director to $50. Still in section 6, current law authorizes counties and cities to issue licenses for the sale of C&B beverages, and it's split into two different ways. If it's a license for giving those beverages in a railway car, it can be from $25 to $50. If it's not in a railway car, it can be, the fee for that license can be from $25 to $200. And so the House bill changes that around where it authorizes the counties and cities to require a local license in addition to a state license if they wish, and that license can be from $25 to $200. And then it separately specifies that a $100 fee for railway C&B retailer licenses can be required. And then jumping down to section 7 on page 14, current law allows counties and cities to issue special event retailer permits for the sale and service of cereal malt beverage on unpermitted premises subject to certain conditions. The bill would allow counties and cities to now request that the director issue those special event retailer permits. In section 8 on page 15, current law requires licensed premises to be open to the public and law enforcement during business hours, with exceptions for clubs, but the bill would change this to require licensed premises to allow immediate entry and inspection by authorized agents of the director or law enforcement at any time the premises is occupied. Refusal of such entry shall be grounds for revocation of the license. And then through sections 10, 11, 12, again, some conforming technical changes, changing those current references of retailers to references to licensees. I'm going to jump to page 18 in section 12 that discusses the appeals process. Under current law, it allows licensees to appeal revocation or suspension orders to the district court. The bill will change this to require suspension or revocation proceedings to be conducted in accordance with the Kansas Administrative Procedure Act. So the initial step for the appeals process would be a little bit less formal, I guess you could say. And this hearing, it would also include a hearing before the director. Additionally, the bill would allow cities or counties to request the director to hold a hearing on license revocation or suspension, and it requires reasonable cause. It grants the governing body the right to appear and present evidence at the hearing and directs the director to consider their recommendations. And then going to page 19, section 13, this discusses prohibited practices for on-premise retailers. The change here is that under current law, it allows the retailers to sell C&B in pitchers on the premises. This would now expressly allow 6% ABV beer to also be sold in pitchers. And then lastly, I'm going to jump to page 20. In section 15, it discusses citations and civil fines. The bill would authorize citations and civil fines to be issued to a licensee for violations of the Kansas Cereal Malt Beverage Act, the Kansas Liquor Control Act, the Kansas Club Drinking Establishment Act, or related rules and regulations. Current law only makes reference to the current sell and consumption, like violations of the current CMB Act. And so this would expand that just a little bit. So sorry, that was a lot of information, but I'll be happy to take any preliminary questions.
Thank you for that, Kyle. Questions? Representative Clayton?
Thank you, Mr. Chair. Not a question, just so much like as a point of clarification, I'm hearing sort of a mix of the term premise and premises. Premise is an idea, and I think that in the IT world, they got too lazy to use the extra syllable and started normalizing the term premise when they meant premises. Premises is a place. If we can just never use the word premise in the place of premises ever again, especially when we're talking about liquor law, I would be grateful for that, because I need that clarification. I want to make sure that I'm making law based on an actual location as opposed to an idea of a location. We fight over may and shall. I just kind of lost it over premise and premises. I've been holding this back for years. Thank you.
Thank you, Mr. Chairman. I will certainly bring that up to our editor for clarification. I will say, though, there was another bill this year concerning the Board of Veterinary Examiners that similarly used the word premise instead of premises, which I flagged, but I'd received some feedback that for certain industries, they really do stick to using the word premise for some reason, but I agree that it would make sense to conform to perhaps the more proper term.
Well, regardless of industrial terms, we are lawmakers. We have to follow actual definitions of things for what they are. And premises is place and premise is an idea. Thank you again for indulging me. I really appreciate this.
For those of you that have been around for a while, it's not the first time we've heard that speech. Representative Corbett?
Thank you, Chairman. In your reference here, when the facilities could be inspected, you referenced both occupied and business, open for business. The thing that could concern me a little bit, but they may not be open for business hours. There may be people in there doing janitorial work or just doing other things. What kind of problems would that happen for the actual owner of the business if there's nobody there that can speak for them? If someone wants to enter.
So yes, again, the bill does change the inspections to say that any time that the building is occupied, an inspection could occur. I'll let the enforcing agency maybe go into more details about why they wanted that change. I guess notice would be given to the owner, the licensee, of that fact that they would be subject to those searches at those times. So they would just need to be prepared.
Representative James?
Thank you, Mr. Chair. I guess my question is in section 7 of those 3. And it says it removes the Board of County Commissioners and city officials from the process of sole authority, gives sole authority to the director to issue or deny a license. Why? Do you know why that is? Why are they taking our counties and city officials out of it and just one person, one office up here is doing that?
I can't answer to any sort of policy why questions, but I will remind the committee that there is a provision that still allows the cities or counties to require a local license in addition to the state license.
So it'll be additional cost. Is that correct?
Currently, the city or county issues the licenses,
Sure.
and they can issue it for a fee in the same parameters of $25 to $200. The increase in fee would be coming from the state license, which had been $25, and now under this bill is $50.
And then, and they're going to also in section 7 allows the counties and cities to request the director to issue special event retailers permits. Can you talk a little bit about that? The counties used to do that in cities, right? They used to be able to authorize special events.
It would, correct, under current law, it's the cities and counties that issue those special events directly, and now they would need to request
Why?
issuance. I will defer
You
to
got some
our
proponents coming up?
conferees.
Okay, thank you.
Representative McNorton. Representative Wilcott.
Thank you, Mr. Chair. Pretty similar to the former representative's questions here. So currently, just on the licensing side, CMB licenses are currently issued locally at your local county or city level, not the state level. What this change does is allowing the state to issue that license, and then in addition to that, your local one could add. So you may have to have 2 licenses versus 1 with this current change proposal.
From what I understand, that is correct.
Okay. All right. Thank you.
Representative Osman.
Thank you, Mr. Chair. So last year, we passed into law the microbrewery bill, which allows for increased trade for microbrewers, I believe, under like 10,000 barrels or so. I'd like to try to understand the difference between beer and cereal malt beverage and how the bill that the law that we passed last year sort of interacts with this, and if there's sort of any Venn diagram between the two of them.
I'd be happy to answer that question, but I think I'll have to circle back to make sure I'm giving you the most accurate information. But if the director is here, she'll be able to give you a very succinct answer, I believe.
Thank you very much. I appreciate that.
Not seeing any more questions. Thank you, Kyle. And first up, Director Debbie Beavers. Welcome back to committee. Looks like you have some questions to answer.
That's totally expected. Good morning, Mr. Chairman, members of the committee. My name is Debbie Beavers. I'm the Director of Alcoholic Beverage Control. Thank you for the opportunity to let us testify in support of this bill. Just to give you a little bit of background on why the ABC has requested this bill, back in 2017, the legislature passed a bill that allowed cereal malt beverage licensees to sell beer 6% or less alcohol by volume, in addition to the CMB. That bill went into effect in 2019 on April Fool's Day. So the bill also required ABC to have oversight over the sale of beer by the CMB licensees. So CMB is 3.2% alcohol by weight or less. So we have a little gap here. And so ABC is in charge of regulating the sale of beer by CMB licensees, and we don't issue the licenses. So when that bill was implemented, nearly 3,000 licensees were able to sell strong beer. And we estimate that's about 95% of what they currently sell. So they're issued locally by the city or county government, and then they report those licenses that are issued to the ABC. So the current process is that someone goes to the city or county, they complete the application that's on the Attorney General's that they've supplied. They pay the $25 to $200 license fee, which is set in statute, and they also pay the $25 state cereal malt stamp beverage fee. So the city or county collects all that. They process the license, they issue it, and then by the 25th of the following month, they submit this information to ABC, but they only do it when they issue a license. So it makes it really hard for ABC to track and know where these licenses are. The best case scenario is we get the information 2 to 3 weeks after it's issued. The worst case scenario has been well over a year. We can't track them efficiently because we don't know if they've issued a license or not, since they're only required to report when they issue one. So we started having some internal discussions on how can we improve this process? How can we make it more efficient? And so we came up with two things. First is follow what the statute says to the letter of the law, or ABC issue the licenses. So what the law actually says is the applicant submits their application to the ABC and the $25 state stamp fee. The ABC reviews it, they issue the stamp, and they mail it back. Then they take it to the city or county clerk. I've been with ABC for 21 years, and this process, the current process, was implemented, I don't know by what director, but it's been going on for well over 20 years. And it did make it more efficient. They could do it all in one place and then send us the stuff. So we entered into some discussions with the city and the Kansas League of Municipalities and the Kansas County Association to discuss this, the changes, because we can't regulate what we don't know. And when we're not getting the information on the licenses, and we also have understood from both associations that there has been a lot of change in clerks and things over the years. But anyway, so what we proposed was ABC issuing the license, and the license fee at $50. And that is the current possible minimum that they would pay, which was be $25 for the license and $25 for the state stamp. And this should reduce a lot of burden on the local city or county, because we will be charged with making sure that applicants are qualified to hold the CMB license. Our goal was to make as few changes as possible and preserve the income from license fees that cities or counties may have budgeted for. So to do that, we proposed authorizing a local license in the amount of $25 to $200, which is the current statutory license fees. And by doing that, it also gives your local city or county local control. Just like any other liquor license that we issue, if the local jurisdiction requires the local license, they have to have both before they can operate. So we may issue a liquor license, in any type of liquor license, and if the local jurisdiction requires that, they don't, then that licensee cannot sell CMB or beer. So there are technical changes in the bill. Many of the things that were brought up are in current law that just were pulled into this bill in order to be consistent, like the right to immediate entry. That's existing law for any other license issued by ABC. We did do some definition clarifications, because in the CMB Act it says retailer. Well, in the Liquor Control Act, we have retailer. It's a retail liquor store, but it's retailer is the term. So I appreciate the clarification on using terms correctly. So the Cereal Malt Beverage Act had on-premise and off-premise and different fees, and so we made clarifying definitions. It's cereal malt beverage on-premise, cereal malt beverage off-premise, and then the railroad permit is staying at the current $100. So there's no change in taxes. The main change in this bill is that ABC would issue the licenses. The local jurisdiction currently can suspend or revoke a license, a CMB license. ABC cannot. We can only fine them for a beer violation at this time under current law. So we don't know if there's a major impact or not down the road until the bill would be fully implemented. If there's a lot of legal cases, I mean, we may need to reassess that down the road. But to implement the bill, our licensing representatives are already entering this information into the system, so we don't need anything to implement it down the road. After a year or so, we may need to reevaluate. But thank you, Mr. Chairman. I'd be happy to stand for any questions.
Body, any questions? Representative McNorton.
Thank you, Mr. Chair. So explain to me, the ABC is going to give them a CMB license. So what's the local city or county license going? Is that just a business license, or is that an additional CMB license? If you're taking the licensing to your office, what's the local office going to issue? I'm confused there on how that works.
Sure, thank you for the question. Just like liquor license, other liquor licenses that we already issue, there's an authorization in the statute for the local government to require, it's called an occupational license, but it's a local city license in addition to the liquor license. So if the local jurisdiction were to require that, then once they get the CMB license from ABC, if this bill moves forward, then they would take that to the local jurisdiction, and if they require it, they would have to get that local license and have both of them to operate. So that way, if the local jurisdiction did not want this business, they have the right to deny it.
Representative Corbett. Go ahead,
So they're not issuing another CMB license, they're issuing an occupational license, the business, whatever that is. So they're not double dipping on the beverage license.
That's correct.
Okay, thank you.
Representative Corbett.
The question I asked earlier on your inspections, when you go in to do an inspection, what does that entail?
When we go in to do an inspection, we check to make sure the liquor license is valid. We look at the premises. We look, depending on the license type, for instance, if it's an off-premise, we look to see if there's open containers of alcohol in there, things like that. That's what we look at. And then we also look at their invoices and records to make sure they're purchasing from authorized distributors.
I hear that, but when you say you could do this occupied or business hours, a lot of times if it's just occupied, there'll be people there that may not be able to answer any of these questions. And it's just like any other business person, you go through and make sure every day everything's right before you do open. So there's kind of a crack in the window there that I'd hate to see somebody go in there and start looking for stuff with just maybe a janitorial staff or not even a second business person cleaning up or something and trying to get in there and kind of find things that maybe you don't need to find. You know what I'm saying?
I do understand your concern there, and this is existing law for all liquor licensees. It's not a change, it's just pulling it into the Cereal Malt Beverage Act. Typically, this is typically applied after hours. For instance, if you have an on-premise, in this case a CMB on-premise, and they have to close at midnight, and you hear lots of noise and music inside at 2, 3 a.m., and then we can, or local law enforcement can go knock on the door and expect immediate entry if it's occupied.
Representative Wilcott.
Thank you, Mr. Chair. I have a couple of questions. The first one's around the licensing. You say that the ABC has some scenarios where, at worst case, where you're not reported the CMB license for up to a year. Distributors are required to report who they sell their products to every month. So when a distributor basically shows that they've been selling product to a license number that the ABC doesn't have record of, what happens at that point in time?
Thank you for that question. It's very interesting because ABC tracks the state CMB stamp number. We don't have the license number that the city or county issued. So the distributor, when they report electronically, they report a generic county CMB number. So it's impossible to track.
Okay. And one more. This sounds like it's, with the change proposal on the licensing, it's going to be pulling the CMB very close to the other liquor licenses that we have, basically procedures. With our 3-tier system, is there any concerns about at one point getting closer and closer that those blend or cross over in the future of basically eliminating the CMB license and just pushing everybody to a liquor license?
That is not a concern of mine, nor is the intent of this bill. The intent of this bill, honestly, is for ABC to have up-to-date, accurate information so we know where licensed CMB retailers are and we can enforce laws. One other thing that if we don't get them reported to us, we do the random controlled buys, doing underage checks, and they're not in the pool for selection for random controlled buys. So that puts a burden, if you will, on licenses that do get reported timely because they may get selected more often because of this. So for us, it's just a simple issue of trying to make as few changes as possible and ABC have the licensing so that we can have up-to-date, accurate information, know where these businesses are so we can enforce the laws.
Representative James.
Thank you, Mr. Chair. You started out with the conversation that counties and local governments don't get back to you. So why is this bill necessary? Why don't you educate the counties and cities? Because this is going to cost, in the end, it will cost most everybody that operates a business more money because they'll have to buy additional license or permit or whatever you want to call it. It's going to be an additional fee. And then what about the special requests and events? I mean, if you can't even get that from the county now, when somebody wants to have a special event in their county or city, and they're going to have to go to the county or the city and then all the way back to your office just to get approved. I mean, the simple solution is to educate the counties and cities on what you want to do. I don't see an additional law being required for this. I just don't get it. Is there going to be additional monies as well for, you need additional staff if you do this?
Thank you for the question. The intent of the bill is simply to change the licensing, and we have done education. Our licensing reps have tried to track when we issue state CMB stamps to the local city or county clerk. We check first to see if they've reported. That's really the only way we know if they've reported any of the last stamp numbers that they got. So we do that. We have enlisted the help of the League of Municipalities and the Kansas County Association to help educate the clerks. They've done that, and we still have issues. So, I mean, for us, the intent is just to have accurate information. It's also the intent of the bill that those special events, we would license them as well. It wouldn't be a special request to us.
Thank you, Mr. Chair.
Not seeing any more. Thank you, Director. Oh, we got one more. I'd like to, just to kind of move on here for a minute, I'd like to remind the body, we do have 2 more hearings after this, so keep your comments pretty pointed.
This will be very quick.
Representative Sanders.
Thank you, Mr. Chair. I just want to make sure I'm understanding this. So if this becomes law, cities and counties will have no say in issuing a license, correct?
In issuing the state license, correct, if they require.
And the ABC then will issue the license, but cities and counties could revoke the license, but the ABC could not revoke the license. So one group could issue the license, but not be able to revoke it, and another group could not be able to issue the license, but be able to revoke it. Is that correct?
Not exactly. ABC would issue the license.
Could you revoke it then?
We would have the authority to revoke or suspend it.
Okay.
We currently do not. If the city requires a local license, then they can revoke or suspend that one as well.
So you could ABC could both issue and revoke?
Correct.
All right, thank you. Thank you, Mr. Chair.
Thank you, Director.
Thank you.
Next up, we have Spencer Duncan. Welcome to committee.
Thank you, the chair and the committee. I'm Spencer Duncan with the League of Kansas Municipalities. I'm going to try to be brief. I'm going to try not to use the P word at all. And I'm going to try to see if we can get through this and try to explain a few things here for you. First of all, for those of you concerned about local control, thank you. I am sincerely appreciative of that. What I can promise you is I would not be here as a proponent today if we thought at any level this was removing local control, and those are the primary conversations we had from day one with the ABC when they approached us about this. This bill continues to allow us to issue local licenses. So even if the state issues a license, we still have the ability to say no in our local communities. It still allows us to do inspections, it still allows us to do enforcement, and it still allows us revocation. So those are the crucial pieces for us that are still retained in this. Much of what's in this bill in italics is already current law. So some of the things like inspections, reporting, some of those are already we have to do with a lot of these licenses. They're just in this bill to make it more uniform, but they're not new laws that we all have had to live under. here's the problem we face as cities, and we're happy that the ABC has worked with us on this. Current state statute really gives them authority if they wanted to right now to take this back from us, right? But as the director said, 20 plus years ago, they sort of ceded that authority naturally and sort of started passing out the stamps to us and gave us that ability, which we've been appreciative of, but letter of the law needs fixed. And this allows us to clarify the current statutes and retain our local control. And I'm not concerned about this current director being vindictive and taking it now. I'm glad they've worked with us. But under the statute, this cleans up what is otherwise a problem, could be a problem for us if we don't make these changes. And so we just wanted you to know that as cities, we've worked with them. We're okay with this language. I will never speak for the counties, but you'll see they do have written proponent testimony in front of you. And if you start changing any of that, then yes, we will have concerns and we'll be the first ones in here walking you through that. Last thing I'll say is to your point about now, yes, this would mean a CMB retailer would have to get 2 licenses because now you have to get a state and a local, and there is a cost associated with that. That's really a policy decision for you folks to make, right? We just want to, so I will point that out as that's been asked several times. So with that, I'm always happy to answer questions and try to make sense of anything I can.
Committee, any questions? Not seeing any. Thank you, Spencer.
Thank you.
As Spencer noted, we do have a written proponent testimony in there from the Association of Counties. Jumping on to neutral, we have Amy Campbell. Welcome to committee.
Amy Campbell. I represent the Kansas Association of Beverage Retailers. We are the liquor stores, the state licensed liquor stores in the state. First of all, I am really, really grateful that you all are interested in the details of how this will be done and what changes are being made, because in the past, sometimes we've had some concerns that the policy-making body here hasn't weighed enough into how things are going to be done. In 2017, when we passed the beer law compromise, that brought thousands of cereal malt beverage retailers into direct competition with the independently owned retail liquor stores for the sale of strong beer. The result of that is that a large portion of strong beer moved from the shelves of the liquor stores and is being sold in your grocery stores, in your convenience stores, and your CMB on-premises places. At the end of the day, we're not here to interfere with cereal malt beverage regulation in the least, but we do want you to be aware that decisions that you make do have an impact on the retail liquor stores. And so I wanted to stand up to make sure that I was able to answer any questions, to talk about why we support clear distinctions between CMB retailers and liquor retailers. The state of Kansas maintains a separation between the types of licensees based on alcohol content of the product. And that is a clear distinction that is defensible in court, which is very important because the courts have had a lot to do with how liquor is being regulated across this country in recent years. And we want to make sure that Kansas is standing on solid ground. Every change to these statutes can impact any licensee within the three-tiered Liquor Control Act, and it's very important that we be conscientious about how that's done. The beer law compromise was very effective in avoiding some extreme harm that occurred in neighboring states of Oklahoma and Colorado when they made changes to how 3-2 beer there was sold. Interestingly, the pandemic provided a great economic relief to our liquor stores. A lot of people were drinking during the pandemic, and a lot of people were buying it at our liquor stores. That has leveled out. Wine and spirits buying has shifted back and spread out amongst the restaurants, bars, and entertainment venues again. And overall, that increased demand that we had seen from the pandemic is now flattening. So new statutes do have unintended consequences. We want to make sure that you are aware that I'm just going to give you an example of court changes. When the Kansas residency laws were eliminated, it allowed the entrance of a different retailer distributor model utilizing loopholes in our statutes that were never contemplated by our Liquor Control Act. If that had gone through statute, you all would have had a chance to look at it and see how you intended that to happen. But right now, it has blurred the three-tier system. It has impacted a number of liquor stores in Johnson County and Sedgwick County, and we can only hope that our current statutes are going to be up to the task for maintaining a reasonably level playing field as enforced by the ABC. With that, we are neutral on this bill. Again, I would say that many of the requirements that you have pointed out that are in here are already applied to all of the liquor stores across the state. And with that, I'd happy to be able to answer questions.
Body, any questions for Amy? Not seeing any. Thank you, Amy.
Thank you.
And that's all we have on this hearing. We don't have any opponents or, so we'll move on. So committee, I just want to kind of give you another crash course. Welcome to Liquor 101. For those of you who have been around for a little bit, you hear me screaming all the time. Every time we make one little tiny change to our liquor law, it can be catastrophic as far as how many things it touches. This is a CMB bill, and it touches all three acts. And it for definitions, and it's a complicated. You saw the pages from the reviser, how many things that thing touch, and how many things we have to go back and change. So every little tiny, what seems to be a very simple move, is actually a complete set of dominoes stacked up that you're trying not to knock over. But we're going to move on. We're going to open up a hearing on HB 2331. And Kyle?
Thank you, Mr. Chairman, members of the committee. Under current law, each judicial district of the state has a district coroner's office, and in the state there are 31 judicial districts. When someone dies in any suspicious or unusual manner, the coroner or the deputy coroner of the county in which the death occurred or the body was found must be notified and may investigate the death. And when a child dies, a district coroner is required to investigate the death to determine if there are any suspicious circumstances or unknown causes. House Bill 2331 concerns the disposition of bodies by district coroners and their deputies. So this bill does not touch on funeral establishments or crematories. Disposition by those entities are covered by a separate statute, KSA 65-1732. And if you look up that statute, you'll notice that some of the language that was added to that statute for funeral establishments well, it doesn't mirror, but it's very similar to the new language that's being added in this bill. So under current law, the applicable coroner must deliver the body to the immediate family or next of kin. If there are none, the coroner reports and delivers the body to a medical school in accordance with state law. Or if the body is not suitable for use by a medical school, the coroner cremates or buries the body. The bill would allow the coroner to move on with disposition through a medical school, cremation, or burial in cases where there is immediate family or next of kin that have been identified, but then have refused to accept the remains. The bill would also add these additional requirements concerning the disposition of cremated remains. And again, these are pretty similar to current law for funeral establishments. If no one claims the cremated remains within 3 years of the date of death or the period of time prescribed by law for preserving remains, whichever is longer, the coroner may relinquish custody after publishing notice in a newspaper and waiting 30 days for any claims. If a person authorized to take custody claims the remains, they must reimburse the coroner for cremation costs and applicable fees. The remains must be buried in a designated place, or if the decedent was a veteran, relinquished to the Kansas Commission of Veterans Affairs or National Cemetery. The coroner is not required to determine veteran status if informed or otherwise discovers the decedent was not a veteran or did not desire veteran-related services. The coroner's office is not liable for costs or damages arising from disposition of cremated remains, except in cases of gross negligence or willful misconduct. If a coroner determines that property found with the body has insubstantial commercial value, the coroner may destroy or dispose of it without liability. House Bill 2331 would become effective upon publication in the statute book. With that, I'd be happy to take any preliminary questions.
Body, any questions? Not seeing anything. Thank you. First up is going to be Dr. Shelley Stedman, Sedgwick County Regional Forensic Science Center. Welcome to committee.
Good morning. My name is Dr. Shelley Stedman, Director of the Sedgwick County Regional Forensic Science Center located in Wichita, Kansas, standing before you in support of this bill. Our center is unique in that we house both the Forensic Crime Laboratory that serves the Wichita metro area, as well as the District Coroner's Office that serves Sedgwick County and a number of other counties in south central Kansas. Under KSA 22A-215, the coroners in each jurisdiction do have the responsibility to provide a final disposition to individuals who go unclaimed after death. That can result when the next of kin is unable to be located, or in the event that we locate a family, but that they refuse to claim their relative. None of that will change, but the proposed language would provide direction to coroners across the state for how and on what timeline that final disposition could be given to the cremains once they are created. In Sedgwick County, we use a variety of techniques, software, and applications to locate family. In our county, it's actually more common for us to locate family and have them to refuse to claim their relative than it is for us to not locate family at all. After due diligence to locate next of kin, or receipt of family refusal to claim, our contracting local funeral provider will receive the unclaimed body and provide the cremation service. Once the body is transformed into cremains, the box-shaped urn is then stored at their facility indefinitely. Our records go back to about 2008, and back then, Sedgwick County provided a combination of burials and cremation for a small handful of individuals. But that number has grown year after year, and by 2015 and 16, it doubled and tripled. And with rising costs of burials and increasing difficulty securing plots, our county commissioners approved for all unclaimed individuals to be cremated in October of 2016. And thereafter, that number continued to increase. In 2023, the Sedgwick County coroner dispositioned a record high of 93 unclaimed bodies. Many of these have small parcels of property associated with the box-shaped urns, all of which are different sizes because people are different sizes, weights, heights, and shapes. And their property is different sizes as well. This creates an unusual challenge of uniform storage. And as I stand here today, our county has over 5,000 cremains in storage. And while funeral providers have statutory guidance for final disposition of cremains, and law enforcement has guidance for abandoned property, coroners have no such guidance. So what I'm asking today is that you accept this language for much needed direction, allowing for these individuals to be given permanent and respectful disposition. I would be happy to stand for any questions that you may have.
Body, do we have any questions? Seeing none, thank you.
Thank you.
Up next, we have on WebEx, we have Maureen Regis.
Branches.
Maureen, are you with us?
Yes, I am. Can you hear me? Can you hear me?
Maureen, can you hear us?
I can hear you. Can you hear me?
We cannot hear you. You must be muted. Maureen, you need to unmute your computer.
I am unmuted. Can you hear me?
Still no. Okay, I won't let you look at that. I'm going to move on. If you do get that figured out, come back to us, okay? we do have your testimony, and we'll consider that written unless you can come back and visit with us on that. So that was the oral proponents that we have. We do have some written proponents in there as well. Then also we have some neutral, and for neutral, also on WebEx, we have Heidi Goff, or maybe in person actually. Heidi, are you here?
Yes, I'm here. Can you hear me? Good morning.
Okay, you're muted as well.
It shows that I'm unmuted.
We cannot hear you. Heidi, we're going to have to actually, we're going to work on that for just a little bit, so hang tight with us, and we'll see what we can do here. So your testimony's also been submitted. We'll come back to you. Thank you.
Thank you.
Also, was there somebody else that was wanting to speak on this? I thought I talked to somebody earlier that wanted to make a comment on this. Okay, seeing none. I don't have any opposition on this. So, so Heidi and Maureen, we're going to, at this point, we're going to go ahead and put your testimony in as written. Sorry for the technical difficulty. I'm not real sure what is going on there, but I appreciate you hanging out with us and attempting to do this part of it. And thank you for that. So we're going to close this up for now. Now we're going to open up HB 2384. And Kyle? And just want to kind of remind people, we have about 15 people that would like to speak on this one, so we're going to keep things kind of moving a little bit.
Thank you, Mr. Chairman, members of the committee. The bill would authorize the State Historical Society to convey all rights, title, and interest to a specified 11.97 acre property in Johnson County to the Kansas Shawnee tribe. The conveyance would be executed by the Executive Director of the State Historical Society through a quitclaim deed without the need for appraisal, bid, or publication, and would not be subject to certain statutory provisions. This mirrors language that was in a similar bill passed a few years ago. The conveyance would require a review and approval by the Attorney General and would include restrictive covenants prohibiting gaming or gambling activities on the land. Concerning responsibilities of the Shawnee tribe would agree to pay all costs related to the conveyance and grant the state a historic preservation easement in compliance with federal preservation laws. The tribe would agree to not use the land or adjacent land as a casino or other gaming facility. The tribe would engage in formal consultations with the following tribes concerning the rehabilitation of the land and the structures. It would have to consult with the 4 federally recognized tribes in Kansas, which includes the Kickapoo tribe, the Prairie Band Potawatomi Nation, the Sac and Fox Nation, and the Iowa tribe. They would also need to consult with any other federally recognized tribe that had children who attended the Shawnee Indian Manual Labor School. And the tribe would need to provide updates on rehabilitation and management efforts every 2 years for a 10-year period to the Joint Committee on State Tribal Relations. House Bill 2384 would become effective upon publication in the statute book. I'd be happy to take any preliminary questions.
Thank you, Kyle. Bonnie, are there any questions for Kyle? Not seeing any. Thank you, Kyle. First up today would be Chief Barnes. Chief, welcome back to committee.
There we go. Thank you, Chairman Kessler, members of this committee. I appreciate the opportunity today to come before you to support House Bill 2384, a bill that will authorize the transfer of the Shawnee Indian Manual Labor School in Fairway, Kansas, to the Shawnee tribe. My name is Ben Barnes, and it's my honor to serve as chief of the Shawnee tribe. The Shawnee Indian Manual Labor School is an integral part of American history, built on Shawnee lands, by Shawnee hands, and using Shawnee funds. Since its establishment, Until its closure as a boarding school in 1862, this site has been a significant landmark, later designated as a National Historic Landmark. Despite this recognition, the site has suffered from years of neglect. While some recent repairs, such as a roof replacement, have been completed, these efforts are too little too late. There remains no meaningful long-term restoration or maintenance plan which guarantees that this site will continue to decline. For too long, this site has been allowed to deteriorate. A report by Architectural Resources Group, a nationally respected firm specializing in historic preservation, identified severe structural issues such as leaking roofs, windows, and walls, water damage compromising historically significant interiors. 2/3 of the site is closed off to the public, and the West Building, the oldest residential structure in Kansas, is unsafe for entry. The National Trust for Historic Preservation has qualified this site as one of America's 11 most endangered historic places. But rather than utilizing this information to promote addressing these critical issues, those responsible for this site have dismissed those expert findings, sought to discredit preservationists, and rejected offers of assistance. When the National Trust of Historic Preservation offered to raise awareness and funding through its 11 Most program, they rejected the help outright. Instead of taking responsibility, they attempted to discredit the very organization that sought to preserve the site. These actions speak volumes about their priorities or lack thereof. There are two errors in the drafting of this bill that I'd like to point out. We want to ensure that the bill language reflects the language from the resolution that was unanimously adopted by the 4 tribes of Kansas in support of this legislation. We respectfully request that the following amendments be made to this bill. On page 2, line 4, after tribe, by inserting as described in KSA 22-2401 AJ5, and on page 2, after line 7, inserting, after item A, inserting, and representation of the stories of the Shawnee Indian Manual Labor School. With the inclusion of those amendments, the Shawnee tribe, with the unanimous support of the 4 tribes of Kansas and many other tribal nations whose children attended the school, it's committed to restoring the mission as a properly maintained landmark and public museum. In recognition of the broad tribal recognition of the site, HB 2384 ensures that all tribes with historical ties to the school have a voice in its future. The bill requires that the Shawnee tribe engage in formal consultation with the 4 tribes of Kansas and any other federally recognized tribes whose children attended this school. The Shawnee tribes welcomes this requirement because we believe that this history must be told inclusively with all perspectives represented. This consultation will shape how the site is rehabilitated and how history is represented. Additionally, the Shawnee tribe will provide regular updates to the Joint Committee on State-Tribal Relations every 2 years for the next decade, ensuring transparency and accountability in our restoration and management efforts. The Shawnee tribe is not asking Kansas for financial support to save this site. We are offering to fund the full restoration ourselves. With this bill, we will restore and preserve all 3 historic buildings to ensure they are safe, functional, and accessible to the public. Expand and enhance the historical programming to tell the full story of the site's role in Native history and its significance in Kansas history. Provide immersive educational experiences for school children and visitors. Enrich their understanding of this landmark. It'll benefit the surrounding community by transforming a site of neglect into a source of civic pride. Some opponents have misrepresented the fact, claiming that the transference of this site to the Shawnee tribe would put its history at risk. The reality is that history is already being lost. Every day that the site is left to decay, we lose irreplaceable parts of our shared past. Others have expressed concerns about educational programming. We share those concerns about the current operations. At present, only 1 building is open to the public, and existing programming does little to educate visitors about the true history of this place. Instead, much of the calendar is filled with yoga lessons and chili competitions rather than meaningful historical interpretations. With this bill, we will expand access, introduce historically rich programming, and finally provide visitors and students with educational experiences they deserve. We recognize that the site holds deep meaning for multiple tribal nations whose children attended this school. That is why HB 2384 requires ongoing consultation with affected tribes to ensure that their histories are honored and accurately represented. The 4 tribes of Kansas unanimously passed a resolution in support of the language offered to the amendment of HB 2384, making clear that this legislation has the backing of the tribes with the strongest connection to the land. Many other tribes have ties to the school, also support this effort. Only one tribe, the Kaw Nation, has opposed this bill and has refused to even meet with the Shawnee to discuss our concerns. We remain open to collaboration, including with the Kaw. But it's important to note that under federal law, the Kaw Nation has no legal or historical claim to the site. The Shawnee Indian Manual Labor School was built on the Shawnee Reservation. The Shawnee tribe was the last to cede the land. Historically, legally, and culturally, this is a Shawnee place, but more importantly, it's a place of shared history, and it belongs to all who seeks its significance. We're not seeking to change the zoning or remove historic protections for the site. In fact, we will fiercely oppose any attempt to alter the landmark or to use it as anything other than a well-maintained and administered historic site and museum. With the passage of this bill, we can save the site from further deterioration, create a truly exceptional historical experience, and assure its preservation for future generations without asking Kansas for a single dollar. I'm grateful for the opportunity to testify, and I'm happy to receive any questions you may have.
Thank you for that, Chief. I'd like to remind the audience real quick, all signs are prohibited from members and the participants as well. Sorry about that, but that's in our rules. Body, any questions for the Chief? Representative Reese.
Thank you, Mr. Chairman. And Chief, you cited a resolution by the 4 tribes of Kansas. Is there a copy of that somewhere?
I believe it's attached to our testimony.
And second question, Mr. Chair. If you acquire acquisition of the mission, what's your timeline on getting it restored?
It would take 10 years. The plan is over 10 years. It has millions of dollars of restoration needs to be done, and we can't go in there. You cannot buy the materials from Lowe's or Home Depot. A lot of this material would be crafted using period crafted techniques. So this would be techniques that was available to people during the 1830s and 1840s. So it's going to take a little bit of time.
Thank you.
Representative Haskins.
Thank you, Mr. Chair. Thank you for your testimony. And I believe we've heard this bill before. And so just to kind of jump to it, on your testimony, page 2, you give us a pledge that you will do 4 items here. And in no way am I questioning honor or questioning intent of this, but I do understand that there's a difference between the word may and shall when it comes to these bills. Would you support an amendment that would state you shall do this, so it would help with those proponents making sure that we will fulfill? I don't see that in the bill, but if it is, please correct me. But would you support, if it's not, would you support it?
The Shawnee tribe would support that. The tribe has unanimous support of our government to pursue this effort.
Okay, so if there was an amendment to state that you shall restore and expand and provide and benefit, that would be something you would support?
That's 100% supported by the tribal nation, and we have a resolution to that effect also submitted with our testimony.
Okay, thank you so much. Thank you, Mr. Chair.
Representative Corbett.
Thank you. The question I have is, who's responsible for letting this property get in this kind of condition?
I think they'll be speaking next.
Good.
Not Representative Sanders.
Thank you, Mr. Chairman. So I too remember hearing this a year ago. And what seems to me the problem is that the opponents don't believe that you're going to do what you say you're going to do. What assurances can you give this committee and those opponents that you would in fact follow through?
Well, we would have the bill itself has language that this is what the tribe will do. We shall do it. What the offers that have been proposed to the Shawnee tribe thus far are, if I can just speak plainly, Solomon's baby proposition. Chop the baby in half and everything's going to be okay. Right now, the Shawnee tribe is the only one that's committed to making sure and caring about the welfare of the site. We want the entire site whole. We want the entire site healthy. It's not at that place right now, and there's no evidence that the State Historic Preservation Office and the City of Fairway have a commitment to see that in the future.
Thank you, Mr. Chair.
Representative Burkamp.
Thank you, Mr. Chair. Good seeing you again here in committee. Do state laws apply to tribal lands, or does federal jurisdiction trump that?
This would be a fee simple transaction. So this land would be subject to all municipal, state, and federal rules.
Okay, thank you.
Body, any other questions? Representative Wagner?
Yes, Chief Barnes. You talk about spending $15 million to renovate the property. Where is the $15 million coming from? I mean, that's a big chunk of change.
Yes, it is. And the tribal nation has pledged to support that. And I thank you for your question.
Not seeing any others at this moment. Oh, nope, I got one, Representative Lewis.
Yeah, just following up on the question. So it's pledged, but do you have the money?
Oh, we do have the money.
Where is it sitting in a bank account someplace?
We do have, yeah, we do have an excess of that. If you're asking how much money we have on hand, we have more than that much money sitting on hand.
Okay, all right, thank you.
Not seeing any more questions. Thank you, Chief.
Thank you.
I'd like to point out we do have a couple of written proponents as well. And we have one neutral, Chairman Repnick. Are you here, Chairman? Neutral. I have it listed as neutral. Is that incorrect?
No, sir, Mr. Chair, that's not.
Okay, so I assume that will be moved to proponent. Is that correct?
No, I'm listed as neutral, and I am still remaining as neutral.
Oh, okay, okay.
Yes.
Thank you.
Thank you, Mr. Chair, Chairman Kessler, Vice Chair Schmo, Ranking Member Miller, and members of the committee. Thank you for the opportunity for me to appear before this committee. My name is Joseph Rupnick, and I serve as the chairman for Prairie Band Potawatomi Nation. I'm a veteran of the United States Cavalry, and I represent approximately 4,500 Potawatomi people living mostly on our reservation, but within the borders of Kansas, as defined by our 1846 treaty with the United States government. I'm honored here to submit testimony regarding HB 2384. The 4 resident tribes of Kansas believe it is important that ownership of Shawnee Mission historic site and control of the operation be placed with a federally recognized tribe, regardless of which tribe takes ownership of that control. The 4 resident tribes also believe it is important that they be consulted on key decisions going forward. In support of this principle, leadership of the Prairie Band Potawatomi Nation, Iowa Tribe of Kansas, and Nebraska, the Kickapoo Tribe in Kansas, and the Second Fox Nation of Missouri and Kansas, Nebraska have passed a joint resolution supporting the legislation similar to HB 2384. That resolution and a proposed legislative language is attached in the testimony that I have submitted. Our understanding is that the Shawnee Tribe is agreeable to those proposed changes, and the only reason why I appear before you as neutral and not as a proponent is that HB 2384 differs from the legislation by the nation and the other resident tribes in 2 key aspects. First, line 2, or page 2, line 4, HB 23 refers that the phrase described in KS 2401 AJ be inserted after the phrase "for federally recognized tribes." The language is necessary to make clear that the right of consultation specifically refers to the 4 resident tribes of Kansas. Next, we prefer the phrase "and representation of the stories of the Shawnee Manual Labor School" be inserted, page 2, line 7, at the end of the sentence. Language is necessary that is required scope of consultation with the 4 resident tribes and applies to future decisions regarding the content and depictions of history in addition to those decisions pertaining to the rehabilitation of the property. Those 2 provisions are reflected in the attachment of the resolution of the 4 tribes, and I respectfully request that they be included in the amendments for HB 2384. I'm happy to answer any questions for that, and thank you for the time.
Committee, any questions? Representative Reese.
Thank you, Mr. Chairman. And are you representing the other tribes, Iowa, the Sac and Fox, and Potawatomi, or just here representing your tribe?
I can only represent Prairie Band Potawatomi Nation, but I do offer the resolution that was signed by all 4 resident tribes.
Have any of the other tribes pledged or as a guarantor of any financial help with a Shawnee
We
tribe?
have not discussed any financial situation. We just want to make sure that we're consulted on any work that's being done out there to make sure that it fits within our vision of what that site should look like.
Thank you. Thank you, Mr. Chair.
Not seeing any more. Thank you, Chairman.
Thank you.
I don't see any written neutral, and so we're going to jump right into the opponent side of it here. And first up is going to be Patrick Zollner with the Executive Director, Kansas Historical Society. Patrick, welcome back to committee.
Thank you, Mr. Chair and committee, for the opportunity to be here. I'll save you my reading my long testimony and try to summarize some of the history. The Kansas Historical Society was founded in 1875 with the mission to collect, preserve, and interpret our state's rich history. And we want to tell everyone's story and have. This is our 150th anniversary. And for 98 of those years, we have preserved and interpreted Shawnee Indian Mission. In addition to the significance of the site as a mission that served 22 tribes, I did want to point out its absolute significance to our state's history as the office for the first territorial governor, Andrew Reeder, and it's where the first legislature met to pass the so-called bogus laws that would have perpetuated slavery that was eventually overturned. It also served as barracks for the Union troops that fought in the battles of the Blue and Westport when General Price's Confederate Army nearly invaded. And parts of it served as a field hospital after that battle. It was a stopping place on one of the few, if not the only one, still extant that served both the Santa Fe Trail and the Oregon and California trails. Originally, it consisted of 2,000 acres at 16 buildings. 3 buildings plus one historic building that the state built in the 30s, and almost 12 acres remain. It's arguably, and I have to say arguably, but this is the state's most historic site significance. We operate 16 state historic sites. Altogether, we have 56 buildings and 600 acres of land that we manage. In the 1920s, the mission at the then was in private hands, and interest began to save this site. My predecessor, William Connolly, went to work on that. We've acquired our sites in a lot of different ways over the years, and all of those stories are interesting. This ended up being the first and only time that a state historic site was acquired by the use of eminent domain. And one of the property owners objected. It was taken all the way up to the U.S. Supreme Court and upheld. So we went to a lot of trouble, had a lot of help. I've listed all of the women's and other service patriotic organizations. But in 1927, it was acquired by the state. In fact, William Connolly said, no more historic site is to be found in Kansas, or the West for that matter. It was listed in the National Register, one of 26 National Historic Landmarks. We work closely with the National Park Service to make sure every work is done in accordance with the Secretary of Interior standards for the treatment of historic properties. Since 2016, we partnered with the City of Fairway to operate the site, and just now we are finalizing a new 3-way agreement with the City of Fairway and the Shawnee Indian Mission Foundation that will enable sufficient funding for the site for the next 10 years. We absolutely are invested in telling everyone's story. In the past year and a half, we've held 2 consultation meetings where all of the tribes were invited. It is a little bit premature for the reinterpretation, which we do want to do the whole site, because we're wanting to restore the West Building, which I will add was never open to the public. It was the site administrator's building. We've applied for 2 major grants in the last 4 or 5 years. And then just this last fall, we have a new Save America's Treasures grant application totaling $825,000 with a over $400,000 federal share to restore the white building to where it could be used, and we would reinterpret it. So we appreciate the state's investment last year, $350,000 for the new roofs. I think those of you that have seen our newsletter will see that we went to extraordinary efforts to preserve the historic plaster in the attic of the East Building. And we did a photo documentation project that is as extensive as you'll find anywhere in the world. We'll have a feature story on it in the next issue. So for those on the question, I'll just put that up. I would invite all of you to come visit and tour the site. It's not falling down. It's in good shape. It's better than some of our other state historic sites, and we know there's still work. We do have a plan. We submit 5-year improvement plans every year as part of our budget project. So I'd be happy to answer any questions.
Representative Clayton.
Thank you, Mr. Chair. 2 quick questions. One, could you get us the name of the U.S. Supreme Court decision from 1929 regarding eminent domain? I know it's mentioned in your testimony, but I want the actual case so I can read it.
Roe v. State of Kansas.
What is it?
Roe.
Like.
R-O-E.
Huh. Okay.
V. State of Kansas.
That's interesting. I won't forget that
It's
name.
easily Googleable.
Yeah. And so, and then the other thing is I know that a lot of the problems that you all are experiencing is due to a cut in funding. Can you remind us, what was the Historic Society's budget request this year, and was it granted? I'm not in approps, I'm in Fed and State, so I miss a lot of that.
We do have, specific to this property, we have an overall budget, which we got roughed up a little bit. But I think to back it up, since you mentioned cuts, we are still receiving less state general fund than we did in 2007. It's been a continual thing, and that started in 2008 with some of the sites going to either part-time or seasonal, and some being operated as partnership sites. So we're still building back. We get $375,000 annually to maintain our 56 buildings. Sorry, I need some water. And we occasionally do ask for specific amounts for additional state general fund for projects. We've not done this at that time, but if we get the West Building at that grant, we may next year ask for some of that matching funds. The foundation is also pledged to raise that if that's not the case. So in short, we do very well with what the state gives us.
What little the state gives you, yes.
Representative Sanders.
Thank you, Mr. Chairman. So there are 3 buildings on the site?
3 historic buildings, yes.
Okay,
East, north,
so
and west.
you say none of them are in bad shape? Are they all in about the same shape?
The West Building needs restored. It was the last resided in the mid-90s, maybe the end of the 90s, with our site administrator. That was the style then for them to live on site. And so nothing has been done since then. And there was some water damage from a frozen pipe. That actually gave us the opportunity to remove the non-historic restrooms that were placed in there. So again, yes, I'd be happy to give you a tour.
So one's in not so good shape, but
Right,
the other
it
two
needs
are,
restoration.
the other 2 are fine?
They're, right, well, you can always do things. It's like this building. How many hundreds of millions did we spend? You could probably find some more money to spend on
Would
this.
you
Yes.
characterize the other 2 as fine or not?
They are fine.
Thank you.
And I would hope you would come see that.
Representative Corbett.
Thank you. The question seems to pop here, how does the state, and it seems like whenever the state gets something or runs something, it continually decreases in value or whatever. But how can you let a building not have attention since 1990? I mean, that's a pretty good stretch.
That's not accurate because we have done several projects. We repointed the brick exterior. We did a window restoration project, and it has current, new, up-to-date HVAC. It actually has air conditioning. Some of our state historic sites do not. So that's not true. The interior has not been restored. The building has been maintained.
The building itself right now is weather tight?
Yes, it has a brand new roof on it. Looks great.
Representative Haskins.
Thank you, Mr. Chair. Thanks for your testimony on this subject. And I would love to have everybody get on a bus and go on a field trip here. But I'm on your website and I'm looking at a video of the museum, and it does look like it's well maintained for the age of this property. And so I'm kind of interested in why would we get rid of this if we're able to maintain it and it has such a historical value to the state of Kansas? And so I'm confused because it looks like it's all maintained well.
That's an excellent question. We again oppose this bill. We do want to tell everyone's story. We know the exhibits that are in the East Building, I think they were completed in 2006. They're due to be reinterpreted. We want to be able to tell stories on all three buildings, so that is our goal.
Not seeing any more. Thank you, Director.
Thank you.
One point, we do have, let's see here. We do have a couple of written proponents as well. And we also have a neutral. Wait a second, wait. Sorry about that. I went back instead of forward. Next up, we're going to have Anna Kostulik up. Now going forward, I know we've already just went past our time, so I don't want to cut anybody short, but if you could kind of give us the couple-minute version instead of reading the testimony, it'd be great. We do all possess your testimony.
Good morning, Chair and committee members. You can hear me, thank you. I will be brief in this morning in order to cede time to the conferees who are here today. And I did want to thank you for your pronunciation of my last name. That was very good. It's Kirstelich. I represent the city of Fairway as zoning counsel. I come before you today to speak in opposition to House Bill 2384. The approximately 12-acre parcel that is the subject of the bill is located within the city. The state owns the site. The tribe sought quiet title and possession of the site in the mid-1980s. Based on a claim that the land patent on which the state traces its title to the site was invalid. In November of 1985, the United States District Court for the District of Kansas, however, upheld the validity of the land patent. We believe the best use for this site is what it currently is: a public museum operated by a public institution that is publicly accountable. The state's title to the site is settled. However, HB 2384 would convey the site to the tribe. The tribe could then seek to place the land into trust with the U.S. government, which could create significant jurisdictional questions, and any language in the bill regarding uses may not apply. With that, I will conclude my comments, and thank you for your time.
Thank you for that. Bonnie, we're going to ask questions at the end of the conferees. Thank you for that. Next up, we have Wesley Papan. Wesley, are you here? Welcome to committee.
Thank you, Chair. Thank you, the committee. Ho, Jojo Witashe, West Papan. I'm Kanze. My name is West Papan. I'm Call. You know, our feelings at a Call Nation is that that's historical land belonged to the Call Nation, where the mission's sitting. We strongly oppose any single tribe getting conveyed that land. I would suggest it would stay with the Kansas Historical Society. I would also suggest that we do a GPR, ground penetration radar, up there to find any unmarked graves. You know, them children, there was 22 tribes that had children attended there. I don't know they had a tendency to bury children. They wouldn't send them back to their people, their tribe. And a lot of that, you know, as you look at the Canadian deal here just a while back, how many bodies did they find up there was unmarked. It was terrible. And basically, like I said, I'll keep it short. You can, everything was in that paperwork that was sent. But I just feel like it, or the tribe ourselves, not just me, that we think the Kansas Historical Society should be the one overseeing that. You can't rewrite history. We can look toward the future. We would like to be included with any other dialogue on this later on if any comes up. And I thank you all.
Thank you for that. Next up, we have Melissa Garrett. Melissa, are you with us? Welcome to committee.
LCO and hello. I am an enrolled citizen of the Quapaw, Cherokee, and Seneca Cayuga Nations, and even though I do not speak for my tribes or all Indigenous people, I represent a strong Indigenous presence at the mission and in Kansas City in Kansas. I am the granddaughter of a Carlisle federal boarding school survivor. My grandfather, William Connor Sr., was taken at an early age to Carlisle and was forced to endure assimilation and hardship and unable to return home. In Shawnee Mission, the students were allowed to return home on holidays and for summers, while assimilation occurred at both. Equating them oversimplifies this history and diminishes the suffering endured at federal mandated boarding schools like Carlisle. The Shawnee Indian Mission holds deep historical significance, not only for one tribe, but for 22 tribes. And African Americans and settlers and those connected to the Oregon Trail, Bleeding Kansas, and the Civil War. As a Native American married to an African American and a mother of an Afro-Indigenous child, it is very important to me that all of these histories be represented and not one be above the other. I see an impact of this affecting all of our peoples, and guaranteeing single ownership to one tribe risks erasing this broader history. A strong Indigenous presence does not require exclusive ownership. A collaborative approach in uniting multiple tribes, historians, preservations would be better to honor this site. While the mission played its role in assimilation, it was federally funded but not federally mandated. And some Indigenous leaders at the time viewed education as a tool for survival. The mission head, Thomas Johnson, even advocated for tribes to have their own rights in owning land and granting citizenship. Comparing the mission to the federally mandated boarding schools that sought to kill the Indian and save the man distorts history for political and financial purposes. Historical trauma should never be exploited. The mission's past should preserve with honesty, not for profit or selective storytelling. If the land should be returned, the Kansa, the nation of the ancestral homeland owners of this land should be recognized. Instead of transferring ownership to a single tribe, we should try to preserve an inclusive, multi-tribal, and state-supported preservation model that reflects the full history and the complex history. For these reasons, I strongly oppose. Thank you.
Thank you for that. Next up, Mayor Hepperly. Mayor, welcome back.
Good morning, Chair Kessler and members of the Federal and State Affairs Committee. I am Melanie Hepperly, Mayor of Fairway, and I stand here today with Fairway's City Administrator, Nathan Nogemeyer, to express the City of Fairway's strong opposition to HB 2384. The reasons to oppose this bill are too numerous to state, but I will turn to Nathan, and he will provide facts that, for your information and for your consideration, will express very clearly why the reasons that we oppose this bill. Nathan?
Morning. Thank you, Chair Kessler and committee, for this opportunity to be before you today. A year ago, I stood before this same committee, and I told you that history is not exclusive, it is shared. Few places in Kansas can show the collective history and how that history weaves through people, places, and time than that of the Shawnee Indian Mission. You've heard all about the history, the significance from all the different stakeholders of the site, so I will not repeat that now. But its national significance has been confirmed through its designation as a National Historic Landmark, which is the country's most distinguished historical designation. Today, the mission benefits from 3 contributing partners who spend countless time and energy to preserve the site. We work with tribal elders, we work with tribal leaders, we work with tribal members to grow our knowledge of the mission and to provide a wide range of programming and educational opportunities for the public. We welcome all who choose to visit the site. Some important numbers to consider. Over 12,000 visitors come to the site every year, making it the 2nd most visited state historic site in Kansas, second only to the building where I'm standing in today. 22 tribes sent students to the school where classes were integrated with white students. 30 to 40% of the students who attended the school were Shawnee. A majority of the students came from other tribes. 14 First Americans from 10 distinct tribes have recently provided programs and experience and expertise to the mission, with numerous others advocating for the mission to the broader community. Over 80 tribes have been invited to participate in the future of Shawnee Indian Mission. Nearly 30,000 hours are volunteered annually by local groups, including the Shawnee Indian Mission Foundation, the Shawnee Mission Indian Historical Society, Johnson County Young Matrons, Daughters of the American Revolution, Boy Scout troops, Master Gardeners, and many more. $945,000 has been invested by the city and the foundation and community since we began our partnership with the state of Kansas. Over $1 million has been committed to the site from the Kansas Historical Society for capital improvements during that same time. Every tribe, including the 3 present-day Shawnee tribes, with connections to the site and land, should have an opportunity, an equal opportunity, to be part of its future. This bill speaks of collaboration and consultation, but when you look at some of the tribal documents, it points to a different picture. I would encourage you to look at the Shawnee Tribe's Constitution, where it specifically calls out this land in Kansas, and where they specifically state they intend to exercise full jurisdictional control through their sovereignty. I would encourage you again to review that information on their website. It does not sound like collaboration. Who other than the Kansas Historical Society is better suited to tell the mission's full story and preserve its comprehensive past? Who other than the current public entities involved could be more publicly held accountable for what occurs there moving forward? What will become of the mission if the state of Kansas gives it away? And specifically, what problem is the state trying to fix in doing so? There are far more questions than answers when it comes to this bill. This committee has an opportunity to affirm what the state of Kansas and its people have said for nearly 100 years, and that is the mission stories are too big and too historically significant for any one group or any one segment of the population. Please come to the mission. Come and see it with your own eyes. Many of your colleagues have, and they have left with a much different impression than when they arrived. Come to the mission and let the buildings speak for themselves, because these buildings have a lot to say. Please oppose this bill. Thank you.
Thank you, Nathan. Next up, no, thank you for that. Next up, Catherine Gates. Catherine, are you there? And we only have a couple more minutes here because we all have to be on the floor at 11 sharp. So I hate to rush you, but I appreciate you being here this morning. I'm a little lost.
My name is Catherine Gates, and I'm the chair of the Shawnee Indian Mission Foundation. You've heard all about the history. Please come. You can feel it there. You can feel the wind from the people of the South Wind, the the Kanza from whom our state is named. You can hear the rumble of the wagons as they came through. You can sit in the room where the territorial governor's office was, and also the statehood vote. People really relate to places. And the mission is thriving now under collaborative public-private stewardship. The State Historical Society, the City of Fairway, and the Shawnee Indian Mission are working together so that all stakeholders are represented in planning, programs, and governance with a commitment to a full, unvarnished story of the mission. The partnership benefits the mission by providing greater human and financial resources, as well as a diversity of perspectives and expertise. It also increases the surety of the mission's future over time, as evidenced by our commitment to a 10-year MOU. Yet actually, we believe that our commitment gives the mission another 186 more years. We are investing to make the mission one of the most respected, remarkable, and impactful national historic landmarks in our country, a feather in the cap of all Kansans. Outreach is one of our priorities. First Americans now are involved in all our planning, programs, and governance. 2 First Americans serve as board members and 1 as a committee chair. They have submitted testimony, which I encourage you to look at. They have helped the foundation in partnership with the city to create new programs. At least 10 of those programs in our new Western Academy and Beyond the Classroom series have topics of First Americans choosing, and the First Americans present those topics. We are working together to further learning, appreciation, understanding, and respect in our programs. Funding is another priority. Through community events and donations, the foundation annually contributes $800,000 for operations and $30,000 for programs. In addition, as you've noticed, many volunteers contribute thousands of hours. There is a very strong potential to increase these numbers, and we are working on that today. What is now possible with public ownership and this unique public-private partnership would be lost with conveyance to any one group or any homogeneous consortium. Please think about the value for many people made possible by Kansas ownership for the first 100 years, and now a partnership committed for another century. We all care deeply about this place. This place, the mission, makes our history come alive for people today and can be a great value for future generations of Kansas if you keep it publicly owned. Please do not give it away. It would be an irreversible loss for the people of Kansas and beyond. Thank you.
Thank you for that, Catherine. I was going to say welcome back to committee. When I was reviewing last year's, I noticed you spoke last year as well, so welcome back to committee. Next up, we have a couple more here, just a couple more minutes we have. Next up, we have Grant Glenn. Grant, are you with us? Not seeing Grant. We're going to move that over into the written opponent side. And then we have Penny Gilbert. Penny, are you here today? And Penny, welcome back to committee.
Glad to be here. I am here again to oppose transfer of the Shawnee Indian Mission to the Shawnee. And I am here again because I oppose it because the version of history that Chief Barnes insists on imposing here is very questionable. And I know this will get a laugh because my disagreements with the Kansas Historical Society have been many, but I absolutely support keeping the Kansas Historical Society in charge of this site. If this is conveyed and we have lost the history of the rest of us, the westward expansion, the Civil War, what is our recourse? If the Kansas Historical Society is doing something I don't like, I can complain to them. I can complain to you. And if I don't get any results, I can help elect people who will do the right thing. I also know that when we charged you in 1875 with preserving our history, we assumed that the resources would be provided. The fact of the matter is that the last big go-round of repairs at the Shawnee Indian Mission from 2001 to 4 were provided by private donors. I think the best solution here is that if the Shawnee have the funds and their primary purpose is the preservation of this place, then please, let's work out a partnership between the state and the Shawnee to get these repairs made. If they want to put up matching grants, surely you will respond in kind, knowing that there are repairs that need to be made. Certainly reinterpretation and restoring the buildings to what they were is wonderful, but they will stand for future generations. Again, I oppose, and I hope that you keep it with the Kansas Historical Society. Thank you.
Thank you, Penny. We did have one more, Brian Ferner, that was going to be with us on WebEx, but I was told that that is not there. Yes, sir. Okay, we have just a minute here for you. Come on up, sir.
Hi, I'll make this quick. My name is Brian Freiner. Thank you for having me. I urge you to vote against House Bill 2384, which seeks to transfer ownership of publicly held land in Kansas. This move would erase the historical legacies of the many communities shaped by the Shawnee Indian Mission Historic Site over centuries. The 12-acre site has been central to Kansas history, yes, from its role as a boarding school, also to its significance in Kansas statehood, in the story of bleeding Kansas, westward expansion via the Santa Fe, Oregon, and California trails. Additionally, the Works Progress administration left a lasting imprint on the many buildings on the site during the Great Depression. As a professor of history, specializing in the American West and American environmental history, I share the scholars in my field's interpretations that historic sites are contested spaces. They reflect the complex stories of those who have occupied them. And so transferring ownership of this land to a single out-of-state entity threatens to erase these histories and silence the many voices that have given the site meaning over time. Very critically, no historians were consulted in the architectural report commissioned for this site. That report focuses only on structures, and it omits the broader historical and cultural analyses that would be important to make any justification, to justify any transfer of title. The very report by the architects calls for 4 additional reports: a historic structure report, a cultural landscape report, a master plan, and an interpretive plan, none of which have been undertaken to date. These are practices common to my profession as a historian. Historical work takes time, a commitment, and community engagement. Multiple voices shape these historical narratives. This is common, established practice in the historical profession. So I leave you with this question: what historical precedents justify relinquishing this site, effectively erasing its history? Do we know? If this land is transferred without proper historical study by historians, Kansas will lose access to a crucial part of its past forever. So I urge you to prioritize research, preservation, and public access over an irreversible decision that would strip Kansas of one of its most historically important sites. Thank you very much.
Thank you for that. Committee, we have just a minute or two for questions, if there are some questions. Representative Wagner.
Yeah, real quick to the, I guess not for you, I'm thinking of the State Historical Society person. About a year or two ago, you folks were willing to give up, I think it was like the Kickapoo Mission that was tied to the Presbyterian Church. And so what is different about this? I mean, you were willing to convey it back to the Indian tribe, and here you're not.
Every situation inside is different. That mission had been closed since maybe 2009. I can't remember the exact date. It operated as a mission for a relatively narrow period of years, 3 or 4. Did not really have additional state or related history. We had about a third of the original building. The rest of it ended up in some of the buildings there in Highland. It was a worthy site. Again, it had been reinterpreted to tell a broader story. It was called the Native American Heritage Museum, and some of those exhibits will until recently were on display at Shawnee Indian Mission. So,
Not seen any more. Thank you, Patrick. I do want to point out, committee, that we do have, there are 45 written opponents as well. So those are in your S drive, so please pull them up if you haven't read all of those yet. And if there's no more on that one, we're going to close this part of the hearing. But I'd like to reopen up real quick bill introductions and Representative Essex.
Third time's a charm. I have bill number RS 1604, requested by Representative Laura Williams, requiring previous convictions to be considered in determining bond when a person is arrested for certain sex offenses.
Body, are there any questions? Not seeing any. Without objection, introduced. Thank you. Body, that's all we have, and we are on the floor in a couple minutes, but thank you, and I apologize for running late, and thank you for your patience. This is adjourned.